Hey, everybody. Hello. Hello. So I know I said hi to you guys, but I'm going to throw it up on screen. Gene P, hello. I'm glad you got the notification. I'm starting a little bit early because there's more documents that came out overnight. So I didn't see them until now. So we've got a few documents to go over while we're waiting for court to start. I've got the courtroom up and waiting. As soon as they start, we're going to jump to it. Okay, well, let me introduce you to Betty.ca. Here's the deal. You can start playing with just $1. Let me try and turn this down. $1 and you're in. No big commitments. I don't know why. Oh, because I'm on. Oh my God, you guys. Give me a second here. Let me turn this down. Okay, because I have got, you should see this. I've got my laptop, I've got my 2 screens up on my computer, I've got my iPad up, and I'm watching a whole bunch of different things all at once going on. I'm watching for the verdict to see if the verdict comes in the Karen Reed trial. I've got another one, the college kids there where one was stabbed to death. I got that one up on my laptop, and then I got this up on my computer. So, it's going to be a day, you guys. Shy, hello. I liked it. It's very deep, Shy. Very deep. And I've got through most of it, but yeah, I've got a lot of projects on the go here at home. I haven't got through the whole thing. I think I'm about halfway through, and I think it's fantastic. And it's very deep. It's very raw. It's very honest. And I just want to give you a big hug. Girl, I'm just glad you're here with us. Put it that way. TK Sass, hello. And welcome. Carol, hello. Always hello. Nana, big hugs, Nana. Cat H, hello. K Mitch. Okay, so let's get going on this. Let me bring this screen up. Okay, which one is it here? Why don't I just share the entire screen? Because I've got everything up here. So anyway, so where we left off behind is somewhere down here. We gone over a lot of these documents. Now, I'm going to go a little bit in depth on this because there's documents that have been filed, you guys, that aren't listed here. And I will show you that, no need to worry. I'll give you my best rundown of what I think is going on, and you'll have a lot more information. Now, there's another person that came forward that was with the DoorDash driver, um, has come forward and said that she's seen Bryan Kohberger. So now, was she close enough to see his face and everything else? I don't know, but I just got wind of that not long ago. So there's more than just Dylan Mortensen, right? That's seen him. There's somebody else too, and seen the car. So that's going to be interesting. A lot of stuff coming out. How is this going to play out? We're going to find out today, right now, as soon as court starts. And as soon as it starts, I'm jumping to it. There's some today that we are not allowed to hear, and that's regarding the alternate perpetrator. I don't think the judge is going to let it in. I'll let you know why when we get to that point. But we are going to see the motion on to have this continued. The defense does not want this case to go ahead August 11th. I'm going to be pissed if it's not, because I've arranged a lot of my schedule for the summer and everything else around this trial so I can bring it to you guys, right? Thank you, Gene P. Gene P says, you sound great. Thank you. Okay, so the motion to seal the defense motion and order for independent analysis of evidence. Okay, motion to seal defendant's notice of filing amended exhibit chart. There's an order sealing the amended exhibit chart of the defense. Motion to seal state's motion to amend the witness list and supplement expert disclosures. There's a motion to seal the defendant's reply in motion of support for access. Now, what this one is here, you guys, this is the defense wanting information of some kind. Either it could be work product, it could be, we don't know what it is, but they are requesting access to something that they feel that the prosecution has that they don't feel that they have yet, or that they may not even be entitled to, like a work product or something like that. I think this is going to be denied. Motion to seal defendant's reply to state's objection to the defense's offer of proof. Like I said, I do not think that this is going to go through. This has been sealed, so like you can see here, we can't see it. But let me make it a little bit bigger here. I don't think the judge is going to allow this. There's been a lot of fighting on this regarding it. You're going to see when I show you the other documents. The prosecution is fighting against this. The judges also said that you can't just throw a name out there. You better have proof. Now, Ann Taylor said in the last hearing, she says, we've come across a tip that was buried in all the disclosure. So is that enough? I don't know, because the prosecution is really fighting this one hard. Okay, so order sealing defendant's reply in support of motion for access. They want to access something that the prosecution has, and the prosecution is saying, nope. Order sealing defendant's reply to the state's objection to defense's order of defense's offer of proof re alternate perp. That's what's happening. Either it's already happened this morning or it's happening after this hearing, and we're not allowed to see it. Now, there will be an order on it, so I will be able to kind of in the back door there see it, but whenever that order does come down. Order sealing state's motion to amend witness list and supplement expert disclosures. I know there was some kind of order on adding new evidence and stuff like that the judge, I think, denied. But we'll have to wait and see. There should be something brought up about that. Maybe today, maybe not. Today, basically, you guys, is we're going to see if this is going to be continued or not, right? Defendants, now this is the new stuff that I haven't seen yet, okay? So the defendants replied to the state's opposition to the defendant's motion to continue. So there was another one that was filed. This just went, even though it says the 16th, this wasn't in the record yesterday when I checked at 5 p.m. Eastern. So this has been added since yesterday after 5 p.m. Eastern. Motion to seal exhibits to state supplemental response to request for discovery regarding expert testimony. State supplemental response to request for discovery regarding expert testimony. I think this is sealed. Yeah, we're not going to see it. It's only 3 pages and it's been sealed. But it does say, let's see what it says. It's just going to say that they want to file it under seal, I think. Comes now the state in the above titled matter and submits the following supplemental response to request for discovery regarding experts, which the state may introduce at trial pursuant to Rules 702, 703, 705 of the Idaho Rules of Evidence. It is anticipated the state may call Dr. Christian Westing. See Exhibits S1, S1A. We know all the S1s are under seal. The state respectfully submits that the above demonstrates that it has fully complied with its duty of discovery and disclosure regarding experts in accordance with the Idaho Criminal Rule 16B and 7. So they're saying, look, we've already given it. We don't know what they're up in arms about, but whatever, right? Motion to seal exhibits to state supplemental response to request for discovery regarding expert testimony. So this is just the motion to seal, and that's all this is going to say, that they want it sealed. Because things in the S1 and everything have been sealed in the past, so they're sealing this too. State supplemental response to request for discovery regarding expert testimony. Order sealing exhibits to state supplemental response to request for discovery expert testimony, and order sealing states ex parte filings out of state witnesses. So there's some stuff I know for a fact that has happened that you don't see here. But what we can see it is over here. Okay, so here we left off here with this emergency order. I believe that this order that the defense filed was the special investigation. So the defense, sorry, I'm just taking a sip of my coffee there. The defense is concerned about this Dateline episode that came out. There's another book that is coming out from another author that's very well known that apparently has a lot of the sealed information in it. I ordered the book. So I will have that book mid-July. It comes out and I'm already on the pre-order list. So when that comes out, you guys, as I go through each chapter, it's 400 and something pages. As I go through each chapter, I'm going to let you guys know what my thoughts are on it. If there's chapters where it's all stuff we already know, I'm going to skip it. But anything that comes out, I'm going to go over it with you. And then once I am done reading it, I'm going to do a giveaway on it like I did with the last book. Okay, so then we did see this. The Judge Hippler sealed his own, stayed his own order that he had made. And that was, I forget what that was about now. I'd have to go back and look, but we got so much to go through here. Let me just see if I can. I think that it was ordering. Let me just see back here. Oh, okay. I know what it was. It was the judge had ordered them to turn over certain stuff regarding Bryan Kohberger's mental health stuff, I believe it was. Don't quote me, you guys. I could be wrong here. I'm fighting a major headache here too, but he stayed his own order. So I guess the defense really fought back on that, so he just stayed the order and said no to it. I just see my other screen pop up, and I thought the jury was back in the Karen Reed thing. So if you guys do want to know the verdict when it comes in, let me know, and I will let you know. Okay, so here we go. This is a lot of new stuff. There's another order that was sealed. Now, there's also this emergency order. I believe this emergency order was for the special investigation. Then there was another motion to seal defendant's second amended phase 2 mitigation witness list. So they're adding people to, they've made a motion to see if they can add an amended phase 2 mitigation witness list. Oh, coughing up a storm here. Jean P says, Willow, I appreciate you reading these motions on how you explain things. Well, you're very welcome. Aw, thank you, Shy. You guys rule. Thank you so much. Okay, so then there's another order here. This is sealing the defendant's second amended phase 2 mitigation witness list. Now, this order isn't on the other page, so I can't see when it was made, but I do know that there is an order because it's here. But I'm assuming it's been since the last time we've gone through this because it wasn't here the last time. So then we got another motion here to seal defendant's motion and order for independent analysis of evidence. So this here, I don't know if they were granted it because it's been sealed, but I believe what this is from the defense is they wanted to do their own independent analysis of the red stuff that was found on the railing coming from the first to the second floor and on the glove that was found outside. That's what I believe it is. Hello, Regina. Hello and welcome. Okay, so then there's another motion here that's sealed. It's a motion to seal the defendant's motion for access and objection to the court's order. So what this is, remember up here, the court stayed his own order, and he sealed that order. Well, now they have an objection to that court's order. So is this something that they wanted and the court said no? I'm kind of up in the air about this. It's kind of hard to read between the lines here with everything that's being filed and is being filed out of order and stuff like that. But there's a motion here to seal the defendant's motion for access. The motion for access is they want to access something that the prosecution has that either one, they're not legally entitled to, or two, they think holds information that they should know. And that could be anything, you guys. Let me just grab a Halls because this is crazy. Willow, get your stuff together here. Okay. So now you may hear my Halls in my mouth. But anyway, they want access to something. And I believe that the prosecution is saying, no, you're not entitled. They're going to fight for access to it anyway. And then there's also an objection to the court's order. So there's an order up here. There's an order, and it's sealed. So they're objecting to this order because I believe this is something totally different. So whatever this order is here, emergency order, did he say no? I don't know. But we know that they have objected to the court's order. Shocking. Okay. So then we have, and as you can see, as we're going through this, you guys, we didn't see this on the other page, right? This other page here is what they post publicly to the site, right? To the judicial branch. A lot of this stuff isn't in here. You got to go over to this. So some of these motions, even though they're sealing it here, so they don't want us to know what it's about. I can come over here and see a bit more information here. Give me 1 second, you guys. Got somebody coming to the door. All right. So now we got another one here, another motion that's done under seal, and the defendant's motion for access and fair investigation. So now they filed a second motion, basically for the same thing that they asked for up here, motion for access again, and a fair did I say trial? I think I did. A fair investigation. So I don't know if the court said, I'm not going to order a special investigation at this time. Is that this order up here? Right here? I'm not going to order it right now. We're still investigating it or whatever. They filed under seal a motion for access, and then they filed it again here. You can see these are two different motions, and they added on this one instead of the objection to the court's order. They ordered here and fair investigation. Right? Weird. It's just odd, you guys. So then there's an objection that was filed, and it's sealed defendant's objection to release a privileged and confidential work product. So this is the defense now saying, we're not handing you stuff. They want all this stuff. They want, work product and everything from the prosecution, but they don't want to give it on their side. So it's like what's good for the goose is good for the gander. Now, it's a Canadian thing. I don't know if you guys have heard that before, but it's a pretty big Canadian thing. But this is also sealed. I know that the prosecution, by reading these back orders and motions, and I don't want to have to scroll all the way back because I have a hard time finding stuff once I found it. But anyway, I know you guys will remember me saying this, that the prosecution wanted to independently evaluate Bryan Kohberger. And the court said no, but ordered that they turn over some reports. So that's what I believe this is. They're going to say that this is privileged and it's confidential and it's a work product, so they don't have to give it to the prosecution. What's the judge going to do with it? I don't know. No, not so much scratch my back and I'll scratch yours. It's like they're asking for work product and all this and access to other stuff that they're not entitled to from the prosecution. But when the prosecution says, okay, well, we want your privileged information and work product, they say no. They're objecting to it. So it's like, what's good for the goose, good for the gander. Don't ask me for something that you don't want to give me. If you want me to give you my work product, you give me yours. They want the prosecution's work product, but they don't want to give theirs. Yeah, he's been pretty much no nonsense, Gene. Hey, Norma. Norma. Hello, my love. Okay. There's more. We're not done. So here, the response. A sealed state's response to defendant's motion regarding the special investigation. So that's sealed. We heard nothing about it up here. Right? But it's here. And then there's a motion to seal state's response to the defendant's motion regarding the special investigation. So now we know it's proven here in these two, right here and right here. It's the defendant's motion regarding the special investigation. Defendant's motion. It's not a motion made by the court itself or the prosecution. This was made by the defense. Now, there's also a mini series that is coming out on Prime Video regarding the Idaho 4, and that is coming out the end of July. It's like the NBC thing, but apparently they have a lot more that we don't know. And that mini series is coming out. There's a book coming out the middle of July, and the Dateline thing's already come out. Now, this is just my thoughts, you guys. Let me know what you think. My thoughts are, whoever did this, it's wrong. There was a non-dissemination order, there was a gag order, not to be talked about, not to be given out to anybody. Things were done under seal for a reason. Did we like it? No. But everybody was to abide by it, right? But the thing is, I don't know exactly what the defense is going to say, but they're saying it's prejudicing Bryan Kohberger. They're not going to get a fair trial, blah, blah. Well, this is all going to come out in the trial. Like, is it wrong that somebody leaked it? Yes. And I'm not condoning that in any way, shape, or form. But it's not prejudice against him because this is stuff that's all going to come out in the trial. Now, if there was stuff that was put forth that absolutely is not true, then I can see it. But this stuff that all came out, like the videos of his car, you know, how Kaylee was found, how Ethan was found, you know, like stuff like that, that's all going to come out in the trial. So you can't claim prejudice if it's true, right? That it's all going to come out anyway. Now, I get them saying, well, it's going to be harder to pick a jury. Well, it's going to be hard to pick a jury anyway. This case is well known from one end of this world to the other, right? So, I mean, it's not going to be an easy process anyway, but I am sure, like, I know us and you guys here with me can't fathom somebody not knowing about this case, but there are a lot of people that could give two flying you know whats about true crime or crime things, stuff like that, right? So, can they find an impartial jury? Yeah. Is it going to be a little harder? Yeah. But I mean, there was so much conjecture and everything else that's going around in on YouTube and Twitter and TikTok and what's the other ones, Instagram and all that stuff. There's enough out there already. You know what I mean? That I don't know. We knew or kind of figured some of this stuff anyway. A lot of it was in the probable cause affidavit. We just didn't see it. So I don't think the judge is going to. I'm crossing my fingers. I shouldn't do that, you guys, because every time I wish for something, it doesn't come true. I get the opposite. So I'm not going to say nothing. I just hope Judge Hippler does the right thing. Me too, Carol. But it's hard to think that there's people out there that don't follow this stuff or like this stuff or whatever because we're such enthusiasts, right? Gene P says, my autocorrect isn't working. I don't think it's not so, not so much that they haven't heard about it. Everybody's heard about it. But can they be unbiased? Can they, you know, put anything that they've heard or seen aside? It'd be nice if you could get people that never heard about it. Could they? They could. Like, look at me. I don't got cable. I don't got, you know, if I wasn't into the true crime because of, you know, working in criminal justice for 30 years, I'm still interested, even though I'm retired. Sometimes I say retarded, but sometimes I'm retired now. I still want to continue on and keep my mind sharp on things, right? Carol says, we're special. We are. It's distracting. I hate this, you guys, because I got my iPad right below my other screen I'm reading off so I can keep an eye on this Karen Reed thing to see if there's a verdict in. Anyway, let's go. Because there's no court tomorrow for the Karen Reed or Friday. None. So if they don't get a verdict today, they come back next week. Okay, where were we? Okay, so here's the next one. Order. And now this is an order. It's not a motion. It is an order. A sealed order sealing the defendant's motion for access and objection to the court's order. So he made an order on this. We don't know what it is because it's sealed. He also made an order sealing the state's response to the defendant's motion regarding the special investigation. What is that? Did he order a special investigation? We don't know yet. Will that maybe be slipped today? We'll have to see. But today we're at least going to find out if they're going to continue this trial. And I hope to the good Lord above he doesn't. We're ready to go. These victims deserve this trial to go through on August 11th. Everything is set in motion for it to go. Let's see. The judge is going to make a decision on that today, and we're going to watch it. Okay, so then there's another motion. This is a motion to seal the defendant's notice of filing an amended exhibit chart. So they want to, now that this, what everybody was calling a dollhouse, I don't like to call it that. It's a replica, not to scale, of the Idaho 4 house, 1122 King Road. Since the judge allowed that in for the prosecution, the defendant has now filed notices of filing of amended exhibit chart, so they're going to start trying to bring in their own charts. Notice of filing, sealed defendant's amended exhibit chart. It's sealed. Order. So the judge has made an order on it and sealing the defendant's exhibit chart. There's another motion here, and it's sealed, as we see. The state's motion to amend witness list and supplemental expert disclosures. And it's here again. This is them sealing it. Here it is here. There's a motion here to seal the defendant's reply to the state's objection to the defendant's offer of proof regarding the alternate perpetrator evidence and evidence in support. So they feel that they have some kind of evidence that proves an alternate perpetrator. They say that doesn't mean they have it. The judge is going to rule on that. If he hasn't already ruled on it this morning, he will be ruling on this afternoon. There's a reply here. Let me just see up here. See, I'm plain close to the details in this case. Okay, so this is also sealed. The defendant's reply to the state's objection to the defendant's offer of proof for alternate perpetrators, not perpetrator, perpetrators, and the defendant's evidence in support of the offer of proof, alternate perpetrator. So here they're saying perpetrators, and here they say perpetrator. So, like, which one is it? So if they've made this mistake alone in their filing, you know what I mean? Here they're saying perpetrators, here they are saying perpetrator. So are they trying to say there was one other person or two or more? You know what I mean? There's another motion here to seal the defendant's reply in support of a motion for access. So obviously the judge probably said no. So they're going to try and fight it. Or the defense has, or the prosecution has said no, they're not entitled to it, and gave, their reasons for that. And the defense is replying to that, and they are giving more documentation and support for the judge to grant this motion for access. And it is here again saying it's sealed. Order, sealing the state's motion to amend the witness list and supplement expert disclosures. So there was an order that was made on that. There's also another order here. These are all sealed. Sealing the defendant's reply to the state's objection to the defendant's offer of proof for an alternate perpetrator and evidence in support. There's been an order. Here's the judge's order for sealing the defendant's reply in support of motion of access. Okay, response for requests for discovery. We just seen that on this page here. Let me just show you. Where did I just see it? See, this is what I mean. Oh, right here. So that's what we just read right here. And the state basically says, as anticipated, the state may call Christian wrestling. The state respectfully submits that the above demonstrates that it has fully complied with its duty of discovery. So this is a mute issue. State supplemental response to request for discovery regarding expert testimony. That's what we just seen. Subject document, motion to redact or seal newly filed record. And this is part of that S1. We've seen it on the other page, the state supplemental response for request for discovery, expert testimony. We did see these, this one, this one, this one, and this one. We did see those over here, but they are sealed. So that was on the other page. 16, the motion, subject document, motion to redact or seal newly filed record. So what has happened is they have sealed it. They haven't put it into the record over here because they were given the option to either seal it or redact it so it could be posted here for us to see. But we know now everything with this exhibit S1, anything with Exhibit S1 is going to be sealed because Exhibit S1 in its entirety has been sealed. So anything, any motions, anything filed in regards to Exhibit S1 is going to be sealed. Motion to redact or seal newly filed records. We know it's been sealed because it has to do with the S1. Reply, the defendant's reply to the state's opposition to the defendant's motion to continue. We did see that and we went through it. It was back here. Right here. And it was 22 pages and we went through it. If you haven't seen it, you can go back to my other video and you will see it. We did go through this document. So we've gone through that. Now, here is today. See, 12:30 p.m. Motion to continue, not sealed. Now, I don't know if they had this one already this morning. Is that why we're not seeing this until this late in the afternoon? Because Judge Hippler was hearing the motion regarding alternate perpetrators, but that hearing is sealed. I do understand why he sealed it, because the defense is going to throw out some names and you can't disparage people without evidence, right? You can't put somebody's name out there in the universe to maybe be a suspect in this if there's not evidence that backs that up. And the judge is going to make that decision. The prosecution has given their go on that, what they think. Let me just get this over here. Okay, because it is going to start soon. Let me get the volume up. The volume is up. Oh, crap. Okay, hang on for a second, you guys. Stop sharing. Because I've got to move this over here so I can keep this, and I got to move this over. I need another screen, you guys. 2 screens is not enough. I need another one. Okay, I'm really interested in this new AP. AP or APs? Huh? You know what I mean? So let me get this up. Hang on. There we go. Nope, that's not it. This is it. Share. Okay, so as soon as court begins, you guys, we will see it there. If you hear something playing in the background, you guys, that's either my laptop or the verdict clock is still going in the Karen Reed verdict watch. And I'm still waiting on the other court case over on the other side. So, like, it's like, I need more screens. Uh-oh. Hang on, you guys. I gotta put up my volume. Is there a verdict?
All right. I appreciate you all getting back here. During the luncheon break, I received word from a court officer that the jury had knocked on the door, indicating that they had a verdict.
Verdict in.
Before I could even summons everybody into court, shortly thereafter, they knocked again and said they didn't have a verdict. So I asked the court officer to tell them to put that verdict slip in an envelope and seal it. And to give it to us. Paul, do you have it?
Apparently the jury said they had a verdict and then they knocked again and said they didn't. So she wants that first verdict slip sealed.
I'm now going to seal it in the legal sense. So this is sealed. No one will have access to it.
No. She sealed it.
Preserved and made part of this record. I'm going to ask it to be marked for identification with the word jury, Chrissy. Just to keep
Can you guys hear this?
Apart from everything else. So it's marked for ID with the word jury.
Hang on, I'll put my mic over to it. So what? They gave a verdict and then they took it back. They said, nope, we don't got a verdict. So their verdict form is now in a yellow envelope that she just sealed.
We do not have a verdict because, as we all know, there is no verdict until it is announced and recorded in open court. So we are still awaiting a verdict. Because it took a while to pull this together, I would ask that everybody remain in the building until the end of the day. So we'll see everybody later.
Okay, so there you go. So what happened there, for those of you, like I said, I've got it up here on screen, you guys. Why can't I put my sound down here? Hang on. Oh, shit. On my iPad, I don't know where my sound is. Is it here? Nope, that wasn't it. Hang on a sec, you guys. Why? Okay, somebody tell me where I can find the. Well, I'll just have to turn it down on my iPad itself. Whoops. Okay. So we are still waiting for a verdict. Oh, shit. I mean, crap. I've got cords coming across and everything, you guys, because my iPad was almost dead. I got chargers. So, okay. Anyway, you guys don't care about that stuff. Where was I? See, look, squirrel. I am sweating. It is so hot here, you guys, today. Let me go put my fan on. I hope it doesn't interfere with our sound. Hang on. Okay, I had to put my fan on. I turned off my air conditioner because it's really loud and because it's right behind me. I'm going to put the fan on. Hopefully it's okay with you guys. Because it is now like almost 30 degrees in my little office here and I am sweating horribly. Okay, so what happened in the Karen Reed thing is the jury knocked on the door and they said that they had a verdict. They had the verdict in a yellow envelope. And then a couple seconds later or a minute later, I guess, they knocked on the door again and said, nope, we don't have a verdict. So did somebody say, no, I want to change my mind? I don't know. Did somebody, make a decision that was going to have them hung again and then change their mind? We don't know. And we're never going to know. Well, I think the judge knows because it comes out in a yellow envelope. I don't know if it's sealed or not when it comes out. But she took the envelope and she had her court reporter put it into evidence. Okay, we got to turn this shit down because I can still hear it. And it's hard to get to my volume button because I've got a case. No, down. Okay, skip ad. Okay, so now they're just waiting for a verdict again. Confusing. GP says, I'm nervous. My heart's pounding for the verdict. Um, I really don't. If you ask me, whoops, jeez, hang on. I did that the last time too, you guys. I forgot to press play here, and it was on pause. Okay, we got the volume all the way up. Okay, let me just check something here, you guys. Give me a second. Hang on, you guys. Oh my god, you guys, I've been talking and my mic was off. Gene P says, what exactly did she say? She said that they gave their verdict, and then, like, within a couple seconds before she could get everybody together, they knocked on the door again and said, no, we don't have a verdict. So the verdict form that was given is in a manila envelope. She has it sealed, and it's going into the record, and she's putting it in the record under jury, like with the title jury, and it goes into the record, I guess. I don't know. Nobody gets to see it. I'm sure she took a sneak peek. But that's where it is. And now they are about to, either give another verdict. Like, to me, it's like, did somebody, I don't know. It could be one of two things, in my opinion. Okay. And only in my opinion. Could it be that Regina says, I had a feeling you were on mute? Yeah. I'm brain dead today. Could it be that one of the jurors or two of the jurors, I'm thinking more along one, has said, no, I'm not going with the rest of the group. So it's going to be a hung jury. And then change their mind? Or did somebody say, okay, fine, I'll go along with everybody else, so we got a unanimous verdict? And then as soon as that paper left the room, did that person then change their mind? It could be either way. This could be good or this could be bad for Karen Reed. So that's that. Yeah, it's like, I don't know what happened to John O'Keefe. I don't know who did it. But what I do know is I don't think the Commonwealth proved their case. This blue paint thing and like just so many inconsistencies, even ones that I picked up that others didn't. And I think I mentioned it here. Like when Jen McCabe was being questioned and um, Jackson was saying, well, when you backed out of the driveway to leave, what side of the car were you sitting on? She said, the passenger. And she said, did you drive past the house when you were leaving? She said, yes. And he said, did you see anything? And you didn't see John O'Keefe on the lawn? She says, well, because she would have if he was there, right? She says, no, because I was turned around talking to the girls in the back seat. But when one of those girls got up on the stand and testified, he said, okay, he says, when you guys got in the car with Jen McCabe and this and that, and you guys were leaving, did you pass in front of the house? She said, yes. She said, well, he said, well, what were you guys doing as you passed by the house? She said, I was on my phone making a TikTok or something like that. What? Jen said she wouldn't have seen John O'Keefe laying there because she was turned around talking to the girls in the back. And when the girl from the back seat was questioned about that, she said no. Jen was turned around facing forward, and the girl in the back seat was playing on her phone when they passed by the house. So Jen lied there too. Like there was just so many inconsistencies on both sides that I don't know. Um, to me, I don't think he hit that corner light. There's just too much against that theory. Did something else happen? Did he turn around to walk away and she winged the glass at the back of his head and cut open the back of his head? Could be a theory, right? Because the prosecution was saying that they were in another fight. That to me would make more sense than him being hit by the car. Because without an injury or anything, no. There's sister. Hello, sister. I think she's guilty. I don't think she's guilty, sorry. But something happened to him. Now, the marks on his arm would not be caused by that taillight, you guys. Like, if he was hit by that car hard enough that that taillight shattered the way they said it did, he would have a broken arm, believe me. Broken bones or bruising or whatever. There's nothing. So it's like, oh my God. Like there's so much that's saying it didn't happen that way. Now, if they retry her again, mark my words, they're going to try and say she threw that glass and smashed him in the back of the head, cutting open his head. And did he fall and then hit his head and that was where he was done for? Is there like a cement thing that holds that pole up that maybe hit his head on that? I don't know. But I know for me to be able to be pondering or even coming up with these scenarios tells me that they did not prove their case. And as far as I'm concerned, they were all drunk. Every one of them drove drunk, right? But we've got people in here saying she's guilty. We got people in here saying she's not. And you know what? I respect each and every one of you and your opinions. Well, no, what's today? Today is we're going to find out if this trial is going to happen on August 11th. That's what we're waiting to find out right now. Is this trial going to happen on the 11th? Because the defense has filed to continue it. They don't want it until next year. Give me 2 seconds, you guys. We're all waiting. So this could very well be, you guys, that they had that other hearing regarding the alternate perpetrator, and it could be going late. Well, I've got the read verdict thing set up here on my iPad, and I've got another court case that I've been watching, kind of, sort of.
Judge Stephen Hippler presiding.
Okay, here we go. I'm going to mute. One in the chat, you guys, if you can hear it, please.
All right, this is CR 0124316665, State v. Kohberger. On behalf of the state, we have Mr. Thompson and Mr. Horwick. And on behalf of, I should note the defendant is present with counsel, Ms. Taylor, Ms. Massoth, and Ms. Barlow. This is the time set for, or at least the public portion of today's hearing is set for the motion to continue the trial filed by the defense. So we'll start with that.
Good afternoon, Your Honor. Your Honor, our motion to continue has been filed and is necessary to protect Bryan Kohberger's rights under the United States Constitution and the Constitution of the State of Idaho. Specifically, a continuance is necessary to protect his due process rights, his rights to a fair trial, his rights to effective assistance of counsel, rights to confrontation, Mr. Kohberger's right to present a full defense, and if it should come to it, a fair sentencing hearing and to be free of cruel and unusual punishment. The record of this case spans 2.5 years, and it shows that this request does not come as a surprise. Looking through the history of this case shows that the defense has met challenges and difficulties along the way, but has been dedicated in meeting all of the deadlines. We have talked about the discovery issues in this courtroom before, and that in large part brings us to need a continuance. 68 terabytes of information is a huge amount of information. There have been 23 requests for additional discovery over the span of 2.5 years and 7 motions to compel. When I say that this doesn't come as a surprise, that this comes from the record, I would direct the court to look back to May of 2023 and June of 2023 and our second motion to compel. Included in that was what was known as Exhibit A from the defense, and that depicted how we were receiving discovery. So this is not a new issue. This is something that's been coming up for a long time. We were receiving discovery, but it was such that you would get a file that would say hundreds of photographs, hundreds of pages of reports, each having to be looked at individually to know what was there and then organized. This case has also faced unique issues, starting with the media coverage of this high-profile case, non-dissemination orders that were addressed in courts, and then the grand jury materials that we had to fight to get access to before we could properly challenge the grand jury indictment. We faced issues with discovery, particularly with the IGG materials. We spent a great deal of time trying to get access to those materials. Those were ultimately what we could get, was ultimately presented in a motion to suppress, and that's preserved should there be a conviction in this case. We faced venue issues in this case, culminating in the change of venue and bringing us to Ada County. At the first hearing in this courtroom, we discussed the discovery issues and not having read everything and being ready with a full investigation in this case. That was apparent through our motions to strike the death penalty, our motions to compel expert disclosures filed in September and December of 2024, and requests for more time to file our motions in limine that was granted in January of 2025. Throughout the course of the motions in limine and then a motion to strike death based on discovery issues in February and March of this year, the record is replete with notice that we are not prepared to go to trial in this case. The discovery is vast and we have not had a chance to review it all. That we met deadlines for experts shows our dedication to comply with court orders. It does not depict effective counsel ready to go to trial on this case. We would submit that it's the court's responsibility to assess this motion to continue with heightened due process that's required in death penalty cases. The death penalty case is different. That comes from Ford versus Wainwright at 477 U.S. 399 at 411. The court must be sensitive to safeguard every avenue of due process. The Idaho Supreme Court said the qualitative difference between death and other penalties calls for a greater degree of reliability when death is imposed, and that comes from State versus Creech, 105 Idaho, 362 at 383. Looking at all of the constitutional rights Mr. Kohberger has, effective assistance of counsel really becomes the crux of how all of these other rights are covered for Mr. Kohberger. And effective assistance of counsel applies both to the merits phase and the penalty phase of a death penalty case. The courts are guided and counsel is guided by the American Bar Association guidelines on capital cases. Wiggins versus Smith, 539 U.S. 510 at 524, said the ABA guidelines are guides to determine what is reasonable. And that's talking about reasonable performance by defense counsel in a capital case. The Ninth Circuit in Andrews versus Davis at 944 F3D 1092 at 1109 relies on the ABA guidelines as the proper measure to test an attorney's investigation. In Idaho, our public defender statutes reference the ABA guidelines as applying to indigent defense. These apply to the full investigation of the merits phase and require us to raise all legal claims. They require us to perform a background on all witnesses that might be called, especially those being called by the state. That means that we have to review all discovery to be able to present a full defense for Mr. Kohberger. We cannot present what we are not aware of. I would note for the court that discovery has been ongoing. I received discovery just this week. It is discovery that I have not reviewed yet. Considering what's required at a penalty phase in a capital case, we're required to perform in a way that the jury can carry out their function of individualized sentencing. That means that Mr. Kohberger's background has to be known and investigated and ready to present to the jurors. Evidence of his character has to be known and ready to present to the jurors, and his circumstances have to be known and ready to present to the jurors. That's addressed in the Woodson case and in the Lockett case. The jury must have the opportunity to consider all evidence that may weigh against the death penalty, and that means anything from his life history. It is the duty of the defense to find and investigate all mitigating information. We do have several experts that would be ready for the mitigation portion of the case should the case reach that phase, and they rely on understanding family history and Mr. Kohberger's own history. They can only understand what they've been presented, and the investigation to fully evaluate needs to be thorough. That means that records have to be collected. That means that interviews, collateral interviews have to be done, and those have not all been completed. And it's not because of a lack of diligence in this case. Further, when things that are noted as red flags arise, those things must be investigated. Red flags aren't fanciful ideas of what else could we do in this case. They're real things that come up in the course of the investigation, and whether or not they're important to mitigation and presentation for a jury's consideration requires time to investigate and collect records. Documentation is very important. The court's aware that red flags have come up and they require further investigation. Those are issues that may mean a lot to the experts that would be ready to testify,
but they can't be presented until there's a full investigation. They are things that might change the course of the evaluation or might require us to have an additional expert to help explain certain circumstances. And that's important for the individualized sentencing that's required by the Constitution. Your Honor, there have been numerous challenges with gathering records and interviewing collateral witnesses. I know the court is aware of some of those particular issues. I'm not going to highlight them now, but it's imperative that we be able to collect records and conduct interviews from other family members besides just Mr. Kohberger and his parents. And it's also imperative that his history be complete with educational records, medical records, and those things are still being done to this day. The other reason that a continuance is appropriate in this case is based on the media coverage, the Dateline issue that has been talked about in this courtroom before, and what's yet to come. The Dateline episode wasn't just a one-time deal back in May. That continues to be talked about. Everything that happens in this case continues to be talked about, and this court has a duty, a responsibility to make sure that Mr. Kohberger receives a fair trial. That comes from Shepard versus Maxwell, 384 U.S. 333. And a continuance may be the way that the court can best protect Mr. Kohberger. That comes from Patton versus Yount, 467 U.S. 1025. In addition to what is going on with what happened with the Dateline episode, that's not all. There's a book set to be released just a few weeks from now to be followed by a docuseries on Amazon Prime. There's a claim that there's inside sources that provide information in this case. At the very least, the moment we start attempting to select a jury in this case, those things are going to be on everybody's TV, everybody's social media feed, and some of the very witnesses that will be expected to testify will be taking part in the docuseries at least, and maybe noted in the book. That is, in and of itself, an exceptional reason for us to have a continuance to let those things play out for a while. I would also note, Your Honor, that jury selection is going to be particularly challenged and will need a great deal of time based on what's happened in the media and continues to happen. Your Honor, our request is for a continuance in this matter to allow us to be effective and perform our constitutional duty for Mr. Kohberger, to protect his constitutional rights, to make sure that we have fully investigated all mitigating circumstances so the jury, if it comes to it, can perform their individualized sentencing, judgment, and function, and to allow some space between what's recently happened in the media. Thank you.
May I, Your Honor?
Of course.
Thank you, Your Honor. I will, I think, address Ms. Taylor's argument sort of in the reverse order in which she raised the issues that she raised. I want to begin, though, by bringing us and the court back to what the standard is for this motion to continue as opposed to what might happen after a conviction with respect to ineffective assistance of counsel. Right now, the standard is whether denying a continuance would violate the defendant's rights by causing unfair prejudice. And that is an objective standard that the court has, and the court has discretion on all motions to continue, including a motion to continue in a case such as this that involves the death penalty. What the defendant and counsel are asking the court to do is delay this trial because of their subjective, prospective beliefs about how an ineffective assistance of counsel evaluation would happen by an appeals court if there is a conviction. What this court should do is use its discretion and look at the objective record. The record supports denying the motion based on what the defense has been doing, continues to do, and will continue to do through the mitigation phase until the penalty phase, including presenting mitigation evidence that the jury will ultimately decide about if there is a conviction. The lens that the court should look at is well stated, through which the court should look at this motion is well stated in some Idaho case law and others. And if I can turn on the Elmo, do I need to hit this button, Your Honor?
And Clerk needs to switch it over.
Okay, thank you. So these are cases that we cited in our brief, and I wanted to start my discussion with them. I'll read the top case, which is an Idaho Supreme Court case, evaluating whether counsel was effective in a death penalty case. Counsel was not required to investigate defendant's entire life in order to objectively and reasonably present mitigation evidence. And then I like the way that the Seventh Circuit sort of rephrased the same principle by saying, I won't read the entire quote, Your Honor, but a scorch-the-earth strategy is not required. We're in a standard of reasonableness. And the record that is before the court, and I'll acknowledge we have not seen what specifics, if any, the defense has put forward in its ex parte filing.
It's kind of hard for you, I recognize.
It does, but we have not seen specifics. I did not hear any specifics from counsel just now about these witnesses need to be contacted, these records need to be obtained. And then the court, I think, mentioned at prior hearing we had when this was motion to continue was first raised, that the court would be looking at what admissible evidence the defense needs to obtain and what strategies would actually be used to fruitfully obtain that evidence. And we don't have anything specific that we can respond to about that. So I'm at a bit of a disadvantage, Your Honor, but I think the record that we do have shows that the court can use its discretion to deny this motion to continue. What we did in our response brief, Your Honor, was to cite the fact that the defense has identified 55 defense witnesses for mitigation, and I think one was recently added, so we're up to 56, 132 exhibits to use at the mitigation phase. And with respect to the ABA standards, we're not saying the court should completely ignore them, but what we are saying is that the court should look at them for what they are, which is a retrospective tool for appellate courts to look at the performance of counsel after a conviction, not some checklist that needs to be religiously adhered to in order to actually get to trial. Even if the court were to rely on them heavily, though, the charts that we put together show that for each of the ABA guidelines categories that the defense has raised, we have seen evidence in the record that shows that they have witnesses to talk about those issues and they have discovery on those issues themselves. Now, defense has called that superficial, but we would ask the court to look at the tables and look at the witnesses that we've been able to identify for each category and also the discovery in the record. So, Your Honor, again, we think that given the legal standards here on a motion to continue, given the court's discretion, given that we are in a world where the court needs to satisfy itself that defense has done a reasonable job to prepare for trial, there is no basis for a motion to continue. Now, let me turn to some of the specific arguments, and I can take this down, Your Honor, that Ms. Taylor raised. With respect to the media coverage, we acknowledge, as the court has, that will pose challenges for jury selection. The issue, though, is not whether there is a lot of publicity. We know there's going to be a lot of publicity regardless of when this trial happens. As Ms. Taylor said, people will continue to talk about this case. The issue is whether the court, using the procedures it has established or maybe even modifying them as the court wants to, can seat a panel of impartial jurors. The Supreme Court of Idaho has found that despite widespread publicity, even on the day of jury selection, that is possible. That is possible in this case, despite the challenges. The other thing I would mention with respect to the publicity is that it puts us at the whim of the media. Every time there's a breaking story, every time there's a new book or a new documentary, are we going to continue the trial indefinitely? And that seems to be the danger in what the defense is asking for. We call it a perpetual continuance, and we haven't seen a proposal about when this trial could take place. If there's a continuance, what seems to be the strategy here is just to delay. And that leads me to, I think, the other point that Ms. Taylor raised, which was to say that this shouldn't be a surprise. It is a surprise to us that a motion to continue was made so late in the game, after, by the way, the trial date was used to oppose an extension that we filed for with respect to our mental health expert. At that point, the defense said we can't possibly go down this road or give the government the state what it wants because of the trial date. Once that issue is resolved, then we get a motion to continue. So I think what we have seen from the defense is that they tried to use the mass amount of discovery to remove the death penalty from the table. When that failed, now we have a motion to continue. So I do think timing is relevant here. Again, and it's not just that the defense waited so long, it's that we now have a very substantial record on which the court can deny this motion based on everything that's been put in front of the state and the court. In terms of the mitigation investigation, Your Honor, we believed but did not have confirmation that the defense had a mitigation specialist until the reply brief on this motion alluded to an affidavit that mitigation specialist submitted. So I don't know what that says. I don't know what the mitigation specialist has said, but the fact that there is a mitigation specialist, apart from the 3 attorneys and 2 investigators that are part of the defense team, that person has one role, as I understand it, which is to prepare for the penalty phase if we get there. And that person, that specialist, has still time to continue doing whatever work they told the court they need to do. Your Honor, again, I would try to get back to the record and ask the court to look at the objective record when evaluating this motion. 55 mitigation witnesses, over 130 exhibits, a very robust team on the defense side, which includes their retained experts. Ms. Taylor, and in the briefing, really honed in on this idea of a social life history for the defendant. I don't know if the court has read the expert reports of the defendant's forensic psychiatrist and then the licensed psychologist. I won't discuss the details in open court, but our position is that both of those specialists, well-trained, very experienced specialists, conducted significant, fulsome life history investigations. They weren't just looking at bare records. They were talking to people from the defendant's past, from his present, his family, and developed parallel life histories. And in their reports, as I read them, no red flags that needed further investigation were noted. Nothing about those reports appeared to be incomplete, and the experts didn't say we are unable to reach the conclusions we need to reach for lack of investigation. So I think that is sort of proof in the pudding. We have a life history for the defendant. The defense has amassed significant materials, and I thought we were going to be solely talking about the mitigation case that still needs to be developed. That is not a basis for a continuance. And to the extent there are ongoing discovery from the state that Ms. Taylor alluded to, I can represent that most of what was just turned over was our investigators speaking with witnesses that the defense has disclosed. So that's the nature of that discovery, is us responding to discovery from the defense. And that will continue, of course, to occur as we lead up to trial and witnesses make statements that we need to disclose to the defense. So with that, Your Honor, I would again rest on the case law holding that a scorched the earth investigation is not what's required. And on the record before the court should exercise its discretion to deny the motion. If the court has any questions, I'm happy to answer those. Otherwise, we would submit on the record before the court.
Thank you.
Thank you.
Any reply?
Yes, thank you. I would start with noting that if the new discovery is the state's contact of witnesses we've listed, the state knows that there are mitigation witnesses that we've listed because we had to disclose them, but they are people that have refused to speak with us. That presents a challenge in the case. A lot of the witnesses that refuse to speak with us have to do with records, medical records of Bryan Kohberger, past treatment records of Bryan Kohberger. Those are important things that the gravity of what they have to say can't be known to our experts until we have the opportunity to fully understand those things. And we continue to work on access to witnesses and access to additional information. Your Honor, I want to touch on just a couple of points. One, when the court considers a continuance and considers whether Bryan Kohberger's rights are violated, his right to a fair trial, his right to confront witnesses and evidence against him, his right to present a full defense, and his right to effective assistance of counsel are implicated and laid out in our motion to continue. The ABA guidelines require us to do a full investigation. It's not going scorched earth to understand Bryan Kohberger's full life history. These are things that are required. And we've done everything that we can. We have had a mitigation expert on the case. This is 2.5 years into a case, and the average for capital cases is 3.5 years.
In federal court.
In federal court.
Which moves at a snail's pace in its best day. In regular cases.
I'm not a practitioner in federal court, so I don't have any basis to talk to the court about that. But what I can tell you is that a capital case where we have a client and we need to investigate both the merits phase and a penalty phase at the same time takes time. In any case, it takes time to do that. In this case, with the high-profile nature and having people decline to talk to us presents a whole set of challenges that we have to find a way to work through. As the court knows, a lot of mitigation information is very sensitive information. It takes some time to be able to get people to talk about things. Realities exist too. Not all of the family members are in the same place. So there's travel that's required. All of those things take time to do in a case like this. 2.5 years is excessively fast to put all of that together. There was no delay in having a mitigation expert on board. There was no delay in getting investigators to work on the case. And as soon as issues became apparent, Mr. Kohberger's team did not delay in getting experts to help us understand specific areas of the case. Looking over the entire record, the court can see that the defense team has been diligent about discovery, about motion practice, about litigating issues in the case. There just still is a lot left to do. There is still a lot left that is not known. And Mr. Kohberger has a right to go to trial with prepared counsel that have conducted a full investigation in both phases of the case. When you have a certain amount of information and there's this other stuff that's out there, that's a red flag, that's real, that you need to investigate, your experts can only do what's here, what's been investigated, what's been produced for them to assess. This whole other area, that land between the red flags and the investigation, That's an unknown area. That's where there's ineffective assistance of counsel. That's where there's not a fair trial. That's where there's not an individualized sentencing proceeding. And it's that area that requires a continuance in this case.
All right, I'll take the matter under advisement and get an opinion out in short order. In the meantime, I fully encourage everyone to continue as if the trial is going to take place when it is scheduled for. Again, I reserve the right to write the decision that I come to, but as of now, I would tell you that it's likely you're going to trial on the date indicated. All right, is there any other matters that we need to take up in the public session before we break to go to the private session?
Nothing further in the public session, Your Honor.
No, Your Honor, I don't believe so.
All right, we'll take a 10-minute break while the bailiffs clear the courtroom and we set up for the private session.
All rise, please.
All right, so there you have it. And I am kind of feeling like by his last comments that I believe that he is going to keep this trial for August 11th. I think if anything, if he's going to do anything outside of not continuing it, I think that it may be like 30 days. You get an extra 30 days, that's it. But I mean, you can't, she shot herself in her own foot. You know what I mean? Like, she took on another death penalty case while she's doing this one that she can't even keep up with. You know, like, that's something you don't do. If you are having a hard time already keeping up with the case that you have on your table, you don't add more to it. Right? What do you guys think? I'm praying too that it stays on track, that he's not going to give this continuance. Like I said, you can't be the cause of the problem, or at least a big cause of the problem, and then cry foul. Carol says maybe she's setting it up ineffective counsel. Well, she already said that out loud. And it's like, the only one that would cause ineffective of counsel is her by taking on another death penalty case. While she is doing this one, she can't even get through the discovery or whatever in this one, if it's true. And what interested me a lot, you guys, and let me know what you think, she had 3 psychologists, neuropsychologists, and all this stuff. She has 3 experts on his past history of mental illness, or, you know, anything that happened in his childhood, stuff like that. She has 3 experts that examined Bryan Kohberger. Like, how many do you need? And over 1,000 pages of expert reports. What more do you need? She is already getting more than most defendants get. Like, what is it now? 5 lawyers she's got on this. She's got, you know, and the team there of these lawyers. She's got experts. She's got law clerks. She's got investigators. She's got, like, I have never seen a defendant that's being paid by the state have this much defending him or her. Ever. So for her to say that with all these experts and law clerks and, everything that she has, that she's not ready, that's on you, Anne. I don't think she should be a death penalty qualified lawyer if this is how she does things. Jean says, I'm sitting here thinking of family and friends of Maddie, Kaylee, Zaina, and Ethan. Yep. Yeah, she's not paying for it. And the longer this goes on, the longer she gets paid, right? Seems to me, Jean says, it seems to me the history on BK would be used during the sentencing phase for the death penalty. Well, the thing is, with this case, when you got a death penalty case, it's like when you go to the next phase, it's like a mini trial within a trial to see if he's actually going to get the death penalty or not. And then there's the sentencing phase. There's three phases. So, and I mean, this trial is going to be going on for 3 months, they say. She still has more than enough time if she wasn't such a control freak. And I mean, she said it herself. I need to look at everything myself. I can't give it to other people to do. I got to look at it myself. Well, no, that's not how a team works, right? If you don't trust your team, then you shouldn't be on a team, right? But the thing is she still has 3 months of trial to litigate to other people. Look at, get this shit together for me because we need it for the next phase. And then there's the sentencing phase, which is even further down the line. So she still has a good 6 months. You know what I mean? Well, okay, maybe not 6, but say 4 months, 5, including July. She's still got 5 months. Exactly, Shy. There is no I in team. Jean says, Willow, you're so smart. You know your legal stuff. Well, I worked in the criminal justice system for over 30 years. I worked for some of the most prominent lawyers in Hamilton, Ontario, Canada. I'm retired now, over 60, has its benefits, but I mean, it's common sense. You know what I mean? It's common sense when it comes to some of these things. And I look at the judge, and the judge, she already lost the judge as soon as she started talking. He was like, he already read her motions and then replies and motions and replies and motions and replies. Like, there's nothing that she said, I don't think, because we haven't seen them. But by looking at the judge, I don't think there's anything she said in this argument, this live argument in front of him, that she didn't already have in her motions or, replies to the state's objections and stuff like that. So it's like, look at, you can only push this out so far before you start looking silly. And she started looking silly a while back. And this judge is by the book. This judge is going to rule by the book. This is not Judge John Judge, where she could bat her eyelashes and, get one over on him. He was so unprepared for what he was about to face with Ann Taylor. And I don't think he ever presided over a case anywhere close to what Bryan Kohberger's case was. He was in over his head and he knew it. I'm talking about Judge John Judge. He knew he was in over his head. And he recused himself when it was being moved. Usually the judge moves with the case when there's a change of venue. But he said, no, not happening. I'm retiring, and I do believe he retired. But I don't know. I have a good feeling, but I've had good feelings before. For the family's sake, for the victim's sake, I hope that this continues on course. I do believe that he is going to do that. I'm crossing my fingers. And Anne better get her shit together. You've had 2.5 years. It's coming up on 3 years. Right? And this happened in November. He was arrested in December. and within days, she was put on the case. You've had almost 3 years, right? So it is what it is. I will keep my eye on the record, you guys. Make sure you're subscribed. Make sure you got your notifications set to all. Keep an eye on my posts on my YouTube channel. For those who are watching somewhere else, make sure you check out my YouTube channel. I will make a post there when I see the judge's decision. Maybe I will even go live with it. I am getting a lot of work done, you guys at home. I know I haven't been doing the mini reads. I'm going to try and do the mini reads tomorrow or Friday. So if you guys do want to have your very own mini read done, come and see me. Watch my channel again. I will announce it beforehand, like early in the morning, that I will be doing them. I'm hoping to do them tomorrow, but if not tomorrow, I will do them Friday. I've gotten a lot of emails like, Willow, we want our mini reads, we want our mini reads. So tomorrow or Friday, I will do the mini read. So if you want your very own mini read, come here and we will go over that. Do you guys want me to play the Karen Reed thing? I have no problem doing that. Let me pull it up and we will watch it from, hang on, let me mute for a minute. Just give me a second, you guys. I will pull it up and you guys can watch. We can. Okay, let me just mute so you don't hear anything. Hang on. Okay, give me a second, you guys. I've got it pulled up. I just want to bring it to where they come in with the verdict. Hang on. I think it's right here. Hang on. Okay. Let me make a big screen so you guys can't see the chat on here. Okay. I'm going to share this with you so we can watch it together. Okay, I'm going to mute, and here we go, you guys. Here is the Karen Reed.
Will the deliberating jurors remain standing? Defendant remains standing. All other parties may be seated.
Your Honor, may the record reflect that 12 deliberating jurors and 6 alternates are present.
Yes.
May I inquire?
Yes.
Mr. Foreman, members of the jury, have you agreed upon a verdict?
Yes.
Thank you. May I see the papers? Mr. Foreman, have the verdict slips been placed in this envelope and have they been in your presence ever since?
Yes.
Mr. Foreman, on docket number 2282CR117001, murder in the second degree, what say you? Is the defendant at the bar guilty or not guilty?
Not guilty.
So say you, Mr. Foreman? So say you? No. Do you agree?
Yes.
Do all of you agree? Yes. Thank you. 002, what say you? Is the defendant at the bar not guilty or guilty?
Not guilty.
Of.
Is not guilty or guilty of that charge or any lesser included charge? Thank you. Specifically, number 5, operating under the influence of liquor by operating a motor vehicle with a blood alcohol level of 0.08 or greater. correct? Yes. So say you, Mr. Foreman? Guilty. So say you all?
Yes.
003, what say is the defendant at the bar leaving the scene after accident resulting in death? Is the defendant not guilty or guilty? Not guilty. So say you, Mr. Foreman? Yes. So say you all? Yes. Jurors, hearken your verdict as the court records that you upon your oath say the defendant on 001 is not guilty, on 002 is guilty of operating in the influence of liquor, and 003 not guilty. Thank you.
All right, jurors, everybody please be seated. Jurors, we thank you for your service. We're going to send you back. Your service is complete. I'd like to come back and talk to you for a little bit afterwards. So thank you very much.
All rise. Jurors, follow me.
What I find weird, you guys, is that none of the O'Keefe family was there.
Karen Reed?
Not
Not yet.
Tony,
Hold
not
on,
yet,
hold on,
not
everyone.
yet.
Karen Reed. Ms. Reed, can I have your attention? As required by statute, I must inform you that the records regarding the charges that you have been found not guilty will be sealed by the Commissioner of Probation by the court unless you notify the Commissioner of Probation in writing within 10 days that you do not want these records sealed. To request that these records not be sealed, you may use the Request Not to Seal form, which is posted on the trial court's website on mass.gov. I cannot accept the form here in court. You must submit it to the Commissioner of Probation at the address provided on the form. Please be aware that if the records regarding the charges which you have been found not guilty are sealed, you will be unable to access the sealed record of the not guilty dispositions or any other records regarding those charges. If you want copies of any documents regarding those charges before the records are sealed, you should request copies from the court within 10 days. Do you understand? Thank you.
All right, so we need a date for sentencing. Can we do it next week?
We can. We would be prepared to go forward today.
Okay.
Perhaps we could approach sidebar briefly.
Okay. All right, so Mr. Yannetti, you're ready to go forward today as well?
Yes, please.
Okay, Mr. Brennan, what's the Commonwealth's recommendation?
Your Honor, the Commonwealth moves for sentencing. We recommend a probation 1 year 24D program.
So the standard that everybody else gets on a first-time OUI?
Certainly.
Okay.
We ask that you be treated no differently, no better. No
So I'm happy to do it.
Thank you.
All right, thank you all.
1 year probation, 1 year probation on docket number 002, the lesser included offense of operating under the influence. 1 year probation. Thank you. The 24D program is. Thank you.
Immediately. All rise.
Goodbye.
All right, so there you have it. No, I muted. Well, I have to mute while this is on because if not, I'll get feedback. I don't have my earbuds in. But yeah, not guilty on all charges. She was only guilty of the OUI, which means she's walking out of there today. She's got a year probation. She's going to have one hell of a fine. She has to complete a program. She's probably going to have that thing that you got to blow into before you get in your car to drive. So she'll have to have that installed. But you think about the alternative. She could have been going to jail for 20 years plus. And I mean, outside is crazy. There's got to be thousands of people outside. But here's the thing, you guys. This is what I want to ask you. Remember that first verdict form that Judge Cannoni says she didn't look at? It's going to stay sealed because the jury changed their mind. I believe she looked at it. Why do I believe that? Because when the verdict came in, nobody was there for the O'Keefe family. They already knew what the jury was going to do. How did they know that? How did they know that? For the verdict, think about that. For the verdict, the O'Keefe family was not there. Yeah, it's her first DUI, so she's got a year probation, and she has to go through that program, which means she has to install that blowing device on her car and that. But that's not what I'm concerned about. I'm concerned about why wasn't the O'Keefe family there to hear the verdict? They already knew. How did they already knew? The judge had that first verdict form that she said nobody looked at, and it was sealed in an envelope. And when you seen in this one, when they read the verdict, that envelope was not sealed. So don't tell me she did not look at that first verdict form. Right? Breathalyzer lock. Yes, thank you, Shai. Why was the O'Keefe family not there? Right, the judge told them. The judge either told them herself or she told somebody else to tell them. Because they've been there this whole trial. Why weren't they there for the verdict? Right? And we had that little slip there with that verdict form, that first verdict form. Oh, no. A couple minutes later, they said, nope, they hadn't reached a verdict. They don't want that verdict form going in. She had to have known that it was going to be not guilty because they did not show up for this verdict. Like, that's big, you guys. I hope, I know there's a couple of lawyers that react to this case. I hope one of them realized that. Like, wait a minute. Why wasn't the O'Keefe family there? Put one and one together. 1 and 1 makes 2. There was 2 verdict forms. She slipped them that information. Well, why couldn't Karen Reed's team hear that? Why couldn't they all see it? She said that it was to be sealed. No one was to see it. If no one was supposed to see that verdict form, then the O'Keefe family would have been there. Right? Am I wrong? Is there something not fishy with the O'Keefe family not being there and 2 verdict forms? Something smells bad yet again in this case. The sad thing is we still don't know for sure, 100% certainty, what happened to John O'Keefe. Who did this to John O'Keefe? Everybody has their theory, but there's only one truth out there, right? And I feel sorry for John O'Keefe. So it's going to be interesting, you guys. It's not going to be pretty. We know that John O'Keefe's brother went on a talk show afterwards, and he had some pretty nasty things to say. I hate to see what's going to be said now, but the verdict is in, and like I said, in my opinion, the prosecution lost this case. I didn't believe from the get-go that they proved their case. There was just too much on the other side that gave reasonable doubt. Why they would allow a so-called expert to paint something and do that kind of demonstration where you clearly see him leaning in. If anything, you guys, if anything, if they did get into another argument, which I don't see where they would have, because they were all lovey-dovey at the bar and everything. She didn't want to go to this after party. Maybe John did. So did they maybe get into an argument? Did she maybe did she maybe throw the glass at her? Did he maybe throw it at her taillight and crack it and her pick it up and throw it back at her? We don't know. Or did somebody else do this. We don't know. And that is the saddest part of this whole thing, is we still don't know what happened to John O'Keefe. We don't know who's responsible. We all have our suspicions. You know, when they were saying that she was going backwards 24 miles an hour and hit him, well, in that case, she would also hit that Jeep, Higgins Jeep, that was parked in front of that mailbox. It was slippery out. It had already started snowing. There was a light dusting. I know, I'm in Canada. I know what winters are like. There's no way she would have reversed in 24 miles an hour and stopped in time not to hit that Jeep with the plow on it. So, I don't know, you guys. We'll see what happens. Have fun. I am turning off YouTube tonight. I've had enough of it. I think if I turn on YouTube at all, it's going to be one of my off-grid homestead places that I like to watch. Nice and calming. But I know you guys are still interested in what, the lawyers and that are going to have to say. And, some of you guys turn into Law and Crime, some turn into Court TV. That's all cool. Go watch it. I encourage it. It's a lot of different perspectives, and we have our own perspectives too, and everybody's entitled to them. That's the verdict. They can't retry her ever again for this. It is what it is, right? It's done. It's over. And I just hope that John O'Keefe can rest in peace. I don't think his family is going to have any peace until whoever did this is held accountable. So until the next time, you guys, I'm going to go out like I always do. I love you guys too. You are very welcome, Shy. Maybe no, I need to wind down a little bit. Maybe I will finish that off tomorrow. But like I said, I'm about halfway through it, and I feel your pain. I really do, in more ways than you can imagine. And I commend you for putting that out there into the universe. And hopefully your struggles that you've been through and the horrific things that you've been through, I hope it helps somebody else that may be going through the same things that you went through. I really do. Okay, so with that being said, you guys, I love you guys to the moon and back. And I'm going to say this like I always do. Please take care of yourselves. Please stay safe. Always be aware of your surroundings and be careful who you trust. I love you guys to the moon and back. Bye-bye for now.